Assistive technology is life-changing for people in need. Assistive technology is a fundamental human right. It is an essential human right. It is a must to everyone who needs an access to assistive technology. These are some of the reasons why legal and policy foundation of assistive technology is created. Greetings to everyone. I am Rolina Manzanillo Fajardo, the reporter for today. Let me begin my discussion to the legislations related to assistive technology, and these are the following. 1. Americans with Disabilities Act, which is approved in 1990. 2. Assistive Technology Act, which is approved in 1998 and amended in 2004. 3. The Rehabilitation Act, which is approved in 1973 and amended in 1992 and 1998. And the fourth one is what we call as Individuals with Disabilities Act, which is shortly called as IDEA. And this act is approved in 2004. The school districts must be knowledgeable about the laws that regulate and form the special education services and the legal implications related to applications of assistive technology. What is about the Americans with Disabilities Act, which is shortly called as ADA and approved in 1990. Again, ADA is signed into law in July 1990. It provides civil rights protection against discrimination for individuals with disabilities similar to the protection provided on the basis of race, gender, age, nationality, and religion. ADA protects individuals with disabilities from employment discrimination based on the disability alone when the person is qualified to perform the essential functions of the job with or without reasonable accommodations. Therefore, as long as the applicant can do or perform the job regardless of the disability, he or she should be accepted for employment. Accommodations may include the use of assistive technology and technology access, unless the changes create an undue hardship for the employer. ADA mandates accessibility and accommodation requirements in public facilities. Employment. The state and local government services. And communication. Americans with Disabilities Act mandates that all new construction and modifications must be accessible to individuals with disabilities. And for existing facilities, barriers to services must be removed if readily achievable. Therefore, public accommodations, public facilities, privately owned transportation systems must comply with ADA standard, must comply with ADA requirements. The second legislation for the assistive technology is what we call as Assistive Technology Act. This is the Technology-Related Assistance for Individuals with Disabilities Act of 1988, which was passed by Congress to increase access, availability of, and funding for assistive technology through state efforts and national initiatives. Technology-Related Assistance for Individuals with Disabilities Act of 1988 forms the basis for the Assistive Technology Act. Technology Act affirms that technology is a valuable tool that can be used to improve the lives of Americans with disabilities. This act supports states in sustaining and strengthening their capacity to address the assistive technology needs of individuals with disabilities. It provides federal funds to assist states in developing consumer-responsive systems of access to assistive technology, services, and information. The Rehabilitation Act. It is an act that was originally signed into law in 1973 and was amended in 1992. 1992 amendments are built on the presumption that an individual is able to achieve employment and other rehabilitative goals regardless of the severity of the disability. Rehabilitation Act required vocational rehabilitation agencies to focus on solutions and attainment of employment outcomes, unless the agency can unequivocally demonstrate that no possibility of employment exists for a particular individual. Options for training, assistive technology, reasonable accommodations, and supports must be carefully considered. Why? Because students who do not qualify for special education may still be eligible for accommodations under Title V of the Rehabilitation Act. This section provides that no otherwise qualified handicapped individual shall solely by reason of his handicap be excluded from the participation in, be denied the benefits of, or be subjected to discrimination under any program or activity receiving federal financial assistance. In 1998, Congress amended the Rehabilitation Act to require that all federal agencies remove barriers to make electronic and information technology accessible to people with disabilities. In Section 508, it establishes requirements for electronic and information technology developed, maintained, procured, or used by the federal government. Section 508 requires federal electronic and information technology to be accessible to people with disabilities, including employees and members of the public. The fourth legislation under assistive technology is the Individuals with Disabilities Education Act, which is again shortly called as IDEA. Assistive technology was not originally included in IDEA, but was later written into the law and placed in the section entitled Related Services. The 1997 amendments to IDEA specifically required that assistive technology be considered for every student with a disability as part of the IEP process. Assistive technology may be considered either as a special education and related 27 services or as supplementary aids and services. In developing the child's IEP, the IEP team must consider whether the child needs assistive technology devices and services. What are the implications of IDEA for assistive technology? It is good to know that with IDEA, all the students now with disabilities are entitled to a free and appropriate public education appropriate to their needs. Students now with disabilities are provided with supplementary services and aids that permit them to benefit from their education. With the four legislations mentioned, access to quality assistive technology is now an urgent need for political commitment. And to improve access to assistive technology, people-centered and assistive technology ecosystem is required. And here's the figure of it. Policy, products, personnel, and provision are the five interlinked areas of people-centered assistive technology. This is a figure for assistive technology ecosystem of World Health Organization. Furthermore, WHO provided policies for assistive technology ecosystem. 1. Recognize assistive technology as essential health products and services that are an integral component of universal health coverage. 2. Develop a national priority assistive product lists based on population need and available resources. 3. Identify effective financing mechanisms that adequately address unmet needs and protect assistive technology users from financial hardship. Establish standards and regulatory mechanisms that ensure production, procurement, and provision of quality assistive products while enabling affordable solutions. Strengthen data collection and information management systems to ensure accurate estimation of population need and demand, while monitoring assistive technology provision. 6. Establish responsive monitoring and evaluation systems that ensure provision of high-quality, affordable products and services that meet population needs appropriately. The policies stimulate regional and international collaboration in research and innovation. In this regard, as an action of our country to the legislations under assistive technology, The universal health coverage, which is RA 10754, is hereby supported by the Congress. And in 1995, the government of the Philippines established a health insurance scheme known as PhilHealth. In pursuit of WHO's vision of health for all, the government passed an act in 2015 that came into force in 2017 to expand the benefits and privileges of persons with disabilities. 10754 mandates a 20% discount and value-added tax exemption for medical devices and assistive products used in and outside hospitals. Rehabilitation service costs and user fees incurred to consult healthcare professionals in both the public and private sector. Once the 20% discount and the value-added tax exemption is deducted, the user then claims the remainder from PhilHealth. Thank you very much. These are the references that I use. To end with, let us all together say, never tire of doing what is right. Thank you for watching.